Major breaking news out of the United States Court of Appeals for the 8th Circuit in the middle of America, covering states like Minnesota and Missouri and the like. A major decision by a potential future Supreme Court Justice David Strauss dealing with whether or not pot smokers, marijuana users, can be disarmed for life and go to prison for long periods of time. Let's talk about what this means for the Second Amendment and this major ruling in the case of United States versus Cooper. Let's get right into it right now. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and the top voice of the Second Amendment in America under the 2025 Gundy Awards. Thank you so much for the great honor. I really appreciate your support for all of you out there who voted for me and showed your support for the Four Box and Diner. It is a great honor and a privilege to be the top voice of the Second Amendment, and I hope to continue to earn your trust in the year of our Lord 2025. All right, folks, so a major win for the Second Amendment in the case of United States versus Cooper, a criminal case dealing with the question whether or not an individual who is allegedly a regular user of marijuana several times a week, who also possesses a firearm, whether or not that law, federal gun control law, 18 U.S.C. 922G, dealing with prohibited people, whether or not that gun control law that says that you cannot be a user of illegal drugs, whether or not that is consistent with the Second Amendment. Specifically, is there an exception to the right of the people to keep and bear arms? The textual right, of course. But is there some sort of historical exception based on our nation's long-standing regulations of firearms? That's the question presented in this case of United States versus Cooper. Now, this case came out of the state of Iowa, by the way. And the facts, by and large, are undisputed as follows. That Mr. Cooper was arrested with a handgun, with the firearm, and when he did so, it was acknowledged and admitted that he used marijuana several times a week and thus was a regular user of an illegal substance, allegedly in violation of 18 U.S.C. 922G3. Well, Mr. Cooper had a bench trial in front of a judge, and the judge found him to be guilty of violating this federal statute. Well, Mr. Cooper raised a Second Amendment defense and said, look, my Second Amendment right to keep and bear arms cannot be infringed simply because I use marijuana. I'm no danger. I've never been a danger. There's no evidence of danger. And because of that, I cannot be disarmed because I have the textual right, because I'm part of the people as an American citizen, to benefit from the right of the people to keep and bear arms shall not be infringed. And because you're disarming me under this federal gun control law, claiming that I'm an illegal user of marijuana, and that is a basis for disarming me, that's a no-can-do. Because textually, I have this right, and the question is, can the government show a long-standing historical tradition that creates an exception to that textual right of Mr. Cooper to possess the firearm, which means the right to keep means to possess, and the right to bear means to carry, for self-defense, for example, in public. Mr. Cooper says, there ain't no historical tradition here. Simply not the case. Well, as it turns out, as a general matter, the U.S. Court of Appeals for the 8th Circuit, in a 3-0 decision written by Dave Strauss, federal judge out there, former Clarence Thomas clerk, who undeniably is on the list of potential Supreme Court justices should a vacancy open up during the second Trump administration. He is the author of this decision, United States versus Cooper. And I thought he did a good job here. He analyzed the case basically correctly. I don't have any major objections to anything he said. And he laser focused on, as did the whole panel, the question presented that really matters as to when you can be disarmed, and that is, are you a violent danger now to yourself or to someone else. As we know from the United States versus Rahimi case, which many of you criticized me and made comments that you thought Rahimi was a terrible decision against us, and I said that's not true. There's many good things about Rahimi, because remember, when you read a Supreme Court case, there's two key facts you always want to keep in mind. One is who wins the case. Obviously, that's important, who wins the case. And in the case of Rahimi versus the United States versus Rahimi, I should say, Mr. Rahimi technically lost that case to the U.S. Supreme Court. However, equally important, if not more so, is how someone wins or loses. And in that case of Rahimi in June of 2024, I apologize for that, the Supreme Court specifically said that Mr. Rahimi himself could be disarmed because it was demonstrated in a court of law that he was indeed a very credible threat to engage in violence to others, because he had been involved in 4 or 5 different shootings, and it was undeniable, and he agreed to it, that he had taken his girlfriend's head and hit it against the dashboard and then shot at a witness. So Mr. Rahimi was undeniably viewed and found to be a violent danger to others and could be disarmed. But here, in contrast, in this case of United States versus Cooper, he was convicted of possessing marijuana and firearms, and using marijuana and having firearms, in violation of the federal prohibited person statute, 18 U.S.C. 922G. But there was no evidence or suggestion he was a violent danger to anyone, at least based on this record, based on this opinion. And that is exactly what this 3-judge panel by the 8th Circuit essentially found. Essentially, the court said that, yes, that statute, as applied to Mr. Cooper, might be constitutional if Mr. Cooper is found to be a danger to himself or to others. But if he's not found to be a danger to himself or others, the statute as applied to him, this was as applied challenge, not a facial challenge. If as applied to him, it might be constitutional if he is indeed found to be a violent danger to others or to himself. Here's what the court wrote that kind of discussed this distinction between dangerousness and not dangerousness. Much of the background work on the drug user and possession statute has already been done. In the case of Veasley, we identify 2 founding era analogs that make it constitutional in certain applications: the confinement of the mentally ill and the criminal prohibition on taking up arms to terrify people. Early in this country's history, the mentally ill and dangerous ended up in jails, makeshift asylums, and mental hospitals with straitjackets and chains. Confinement came with the loss of liberties, including disarmament, to preserve the peace of the community. Those who possessed no danger, by contrast, stayed at home with their civil liberties intact and with their families. Well, that's powerful stuff. Do you see that critical distinction? And by the way, they cite to Alan Dershowitz, who you often see on Fox News, on this topic, the difference between the mentally ill and dangerous on the one hand and those who pose no danger. If you pose no danger, you are able to stay at home with all your civil liberties intact. But if you're mentally ill and dangerous, you would often be locked up in a straitjacket or in a mental health asylum, or what was basically functioned as one back at the time of the founding. But then the 8th Circuit goes on and continues to analyze this distinction between people who are violently dangerous, who can be disarmed constitutionally consistent with the Second Amendment, and those that are not dangerous, who really cannot be, because there's no historical tradition of disarming people that are not dangerous. Here's what the court continues on to say. The question is whether Section 922G3 is relevantly similar to this founding era analog. It is, but not for everyone. The behavioral effects of mental illness and drug use can often overlap, but only the subset of the mentally ill who were dangerous faced confinement and the loss of arms. It follows that for disarmament of drug users and addicts to be comparably justified, it must be limited to those who pose a danger to others. The analogy is complete, in other words, for someone whose regular use of PCP induces violence, but listen carefully, folks, but not for a frail and elderly grandmother who uses marijuana for a chronic medical condition. The latter would regulate arms bearing to an extent beyond what was done at the founding. Exactly right, folks. This is how to analyze these cases under 18 U.S.C. 922G, prohibited people. You got to ask yourself, are these people dangerous? If they're violently dangerous to themselves or to others, I think they can be temporarily disarmed. And by the way, that's exactly what was found in the Zaki Rahimi case in 2024, drawing that distinction between dangerousness and not dangerous, and pointing out that even if you're dangerous, you can only be disarmed temporarily. And I think this analogy that's being discussed here by the Eighth Circuit, drawing the distinction between someone who's violently dangerous on PCP and an elderly grandmother who uses marijuana for medicinal effects because she has a bad back or chronic pain, I think that is materially different under Second Amendment law and just makes a lot of common sense, even though that's not technically the way the law works. But let's go on and see what else the Eighth Circuit had to say in pointing out this critical distinction between dangerousness and not dangerous. Critical distinction. It explains everything as I see it in 922G. The lesson to draw is that this analogy only works for some drug users. When a court has found that the defendant represents a credible threat, a ban on firearm possession fits neatly within the tradition, and so does one apply to drug users who engage in terrifying conduct. And then they cite to Justice Neil Gorsuch, who concurred in Rahimi, pointing out that the Rahimi decision did not decide whether the government may disarm a person without a judicial finding. Hear what I just said? Without a judicial finding that he poses a credible threat to another's physical safety. Okay, key distinction made between someone who is dangerous and someone who's not dangerous. That is the thing you have to continue to think about with these prohibited people cases. And the Eighth Circuit Court of Appeals out there in Minnesota, Missouri, and Iowa, and so on, they're in the middle of the country, did an excellent job of drawing this distinction. I think that's consistent not just with the history of the Second Amendment, which we've talked about before, it's also consistent with Supreme Court precedent of the Rahimi case, drawing this critical distinction between someone who's dangerous and someone who's not. That is key. And by the way, even if they're dangerous, as you know from Rahimi, they can only be disarmed temporarily. And of course, 18 U.S.C. 922G is a lifetime ban if you fall into any of those categories, with a couple minor exceptions. So anyway, there you have it. I will put a link to this decision. And again, keep your eye on Judge David Strauss out there in the Eighth Circuit. He is definitely on the list. We'll see if there's a Supreme Court vacancy at any point in the next year or two. If there is, I suspect his name will be bandied about with several other judges we've talked about on this channel for possibly filling that vacancy. Again, we'll see what the president does and if a vacancy arises, and then, we will see how the world plays out because, as I've often said on this channel, the history of the future has yet to be written. So with that said, make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both here on Rumble and on YouTube, and I look forward to talking to all of you again very, very soon here at the 4Boxes Diner.
Orders up. Table 2A.